Are we waiting for anyone else to come back into the room? We are waiting for someone else to come back in the room, but is there... Ms. Cohen, may we start, or do you need a little bit more time? May we start, or do you need some more time? Well, ladies and gentlemen, we'll recommence with the cross-examination. Ms. Cohen.
Mr. Kaczmarek, in your report, you refer to what is known as the administrative appraisals. You recall that?
Yes, I do.
And with respect to the administrative appraisals, do you know what valuation date they use to conduct the administrative appraisals?
I don't recall all of them offhand, but I believe it was around 2008.
And do you know how they determined the date to use for the purposes of valuation?
I'm assuming they were instructed as to which date to use for their valuation.
Did you consider whether the date that was chosen was appropriate?
No, I did not evaluate the whole process of the administrative appraisals.
Did you review the administrative appraisals and assess the comparables that they had chosen to use in the administrative appraisals?
No, I did not.
Are you aware that with respect to a number of the lots that are an issue in this proceeding, there was a judicial process that followed the administrative appraisals?
Right. It's my understanding that if it's challenged by the property owner, it goes into a judicial process.
And you're aware that, in fact, in this case, there were a number of lots that went into the judicial process?
Yes, I believe that's the case, that there are a number of them there, yes.
And you understand that in the context of the judicial process, there is an appraisal that is provided to the court that is different from the administrative appraisal. You understand that?
Yes, my understanding is it can't be lower, but it could be higher, I believe, the appraisal in the judicial process.
The appraisals from the judicial process are not in the record. You understand that?
I don't recall if they are or they aren't in the
You
record.
didn't review the judicial appraisals prior to providing your opinions, either in your first or your second report. Is that right?
Correct. I did look at the administrative appraisals, but I don't believe we refer to judicial appraisals. It's my recollection.
You're aware that with respect to the judicial appraisals, a number of them resulted in an appraisal of the property that was substantially higher than the administrative appraisals. You understand that?
I don't know if I've done that comparison. It wouldn't surprise me if my understanding is correct that they could only be higher and not lower, that it could be that someone came up with a higher appraisal.
You didn't consider the basis upon which those appraisals used in the judicial context came up with a higher valuation than the administrative appraisals, correct?
I did not, no.
You understand that the principal entrance of Playa Grande is about 650 meters from the beach?
I've not paced it off. I will take your representation that it's 650 meters.
You've been there a number of times. It's a substantial distance from the beach. You agree with that? About almost a mile.
I guess it just depends upon where you consider the entrance to the Playa Grande area.
There are properties within the Playa Grande area that are a distance of about a mile away from the beach. You understand that?
Oh, certainly there are people have homes further away than that from the beach, yes.
And you don't know whether the comparables that were used in the administrative appraisals were properties that were in close proximity to the beach or a mile away from the beach, correct?
I did not analyze the comparable properties they chose, nor how they made any adjustments to those, if any. I did not analyze that.
And you'll agree with me that lots closer to the beach will sell at a premium to lots that are further from the beach, correct?
Agree.
If you look at your report on page 56 and 57, you set out a summary of the administrative appraisals on page 56 is Playa Ventanas and page 57 for Playa Grande. You see that?
I do, yes.
And if you look at the administrative appraisal date for the Playa Grande properties, you see that the administrative appraisal amounts are substantially lower per square meter than the appraisals for the Playa Ventanas lots that were conducted with an administrative date of September 2008 per square meter. You see that?
So we're on table 7.
Looking at table 7 compared to table 8.
Right. So for Ventanas, and again, I'm doing a comparison here of administrative appraisal versus purchase price. To the extent the purchase price is even correct. I presume so in the first report, and many of them are higher, as you can see, than the purchase price in Ventanas. I agree with you. If you go on to table 8 on page 57, the administrative appraisals look much lower, but what you can see is that several of these are purchases by Mr. Berkowitz, and at the time we were told he was buying these properties for $500,000 a lot, and that is the figure we use. So clearly I would have to change this entire table and use the appropriate purchase price, which is some fraction of 1.5 million for all 8 beach lots, which would change this table quite a bit.
Well, we'll come back to that, but my understanding is that you have taken the administrative appraisal amounts and used the administrative appraisal amounts in these 2 tables in reference to the square footage, correct?
Yes, I've done a comparison of the square footage for each property, the value per square meter, excuse me.
So I'm not concerned for the moment with the comparison between the purchase price that you have indicated in your tables as being the appropriate purchase price. I'm just looking at the appraisal amounts. Do you know whether the administrative appraisals took into account the purchase prices with respect to the properties and coming to the fair market value for those properties?
I do not know. I don't know. I would assume. I would assume no, only because if they would have had to submit the sale and purchase agreements, and Costa Rica would have them. So the logical presumption is no, they did not have that information.
Okay, so now just looking at the comparisons between the appraisal amount per square meter It's the only purpose that I'm looking at the moment. You'll agree with me that for the administrative dates that are indicated as being 2006 and 2007, the price per square meter in Playa Grande is substantially lower in the administrative appraisals than the price per square meter that is given to the properties in Playa Ventanas in September 2008.
Yes.
And do you have any understanding of why that is the case?
I can speculate and provide an answer.
Do you know?
I don't know for a fact.
I could ask you to look at page 10 of your reply report. And this is paragraph 32 and 33 of your report. You make reference to the Berkowitz lots, and in particular, you make reference to B8 being listed in 2003, contemporaneously with a beachfront lot that was listed for US $40 per square meter. You see that?
Yes, I was comparing the apparent purchase prices of Mr. Berkowitz with a parcel of property immediately to the south and bordering Mr. Berkowitz's properties that was owned by the Inglaubes.
Mr. Kazmarek, I suggest to you that you didn't actually believe that the amount that was paid for the lots was $1,200 per lot. Is that right?
Well, it's not unplausible in my view. It's exactly what FTI said in their second report. They said FTI stands corrected. The correct purchase price is 500,000 colones. How a buyer prices the risk that the property is in the park and the risk of expropriation is, one could imagine a wide range of potential prices on how someone prices that kind of risk.
Could I ask that the witness be given the binder that was used for the cross-examination of Mr. Berkowitz?
I don't think we have a copy of that right with us.
Mr. Kazmarek, I'm going to suggest to you that given the evidence that you've given today and based on the evidence in your reports, that in your professional opinion, it was not reasonable for you to conclude that the amount paid for those lots was $1,200 per lot. Do you disagree with that?
It's what FTI concluded was the amount paid for those lots.
I'm asking for your opinion.
I would have preferred to see the purchase and sale agreement, as I said in my first report, to confirm it. But this is what I was told, that it was wrong. We had pointed out there's a discrepancy here in the registry amount and the amount claimed. $500,000 at the time seemed exorbitant and out of line, but if you know the property's in the park and it could be expropriated, it could be a plausible price, absolutely.
You've been here throughout the proceedings, and you heard perhaps what I will do is first show you the document. And did you do any due diligence to find out what the actual price paid was?
The only way I could really know is either look at the registry, it's the only public document available, or look at the sale and purchase agreement, but I didn't have the latter.
Do you know whether the sale and purchase agreement has been formally requested? at any point?
I'm not aware of that, but I clearly made my views well established that I felt proper evidence needed to be submitted on purchase price in my first report. It's certainly something I would have absolutely asked for had I been retained by claimants.
And if I could ask you to look, is it the same binder, same time? I don't know if the tribunal still has that cross-examination binder. My apologies. But I would like to show the witness is tab 38 of that binder, which is Exhibit C-23B. My apologies. Now, Mr. Kaczmarek, I believe you did say in your report that you referred to the documents that had been filed in the registry. Is that correct?
Yes.
And looking at Exhibit C-23B, this is one of the documents that you would have relied upon. Is that right?
This is a document, yes, that we looked at and said it does not appear to be correct. Mr. Berkowitz paid $500,000 per lot. He listed it in the registry at 500,000 colones.
And this is the document with respect to Lot B1. You understand that?
It could be. I don't know if I could confirm that just looking at it, but I'll take your representation of it.
And you understand that there would have been similar documents, and you reviewed similar documents with respect to each of the B lots. Is that correct?
Yes, it's my understanding that when property changes hands, it needs to be listed with the registry.
And you looked at those documents with respect to each of the B lots. Is that correct?
Yes, exactly.
And if you turn over to the second page of the document, the reference to 500,000 colones is seen towards the bottom of the page where it says estimate or price. You see that?
Yes.
And that's the figure that you referred to a moment ago that you were relying upon in preparing your expert report. Is that right?
To clarify, when I prepared my first report, I identified this discrepancy, and as I said, I still did some calculations assuming $500,000 was correct. FTI came back and said, we stand corrected. 500,000 colones is the correct purchase price. So at that point in time, I have no other information to believe otherwise, that was the correct price.
So your belief was that 500,000 US dollars was more likely the real price. Is that right?
Oh, no. I mean, that figure jumped off the page at me as being out of line with all of the other purchases. And so I wanted to see sale and purchase contracts so we could get the actual evidence properly into the record and be assured of what prices we're talking about.
Sorry, I'm not sure I'm understanding your evidence. Are you suggesting that the $1,200 number jumped off the page at you, or the $500,000 number?
The $500,000 figure jumped off the page at us, and we said, looks like there's a discrepancy here. Hopefully we could resolve it.
I suggest to you, Mr. Kaczmarek, that $500,000 was, based on your analysis of the market, a more likely purchase price than $1,200 for beachfront property in that area.
You're certainly free to make whatever suggestion you like. I completely disagree with the suggestion that if one's purchasing beachfront property that's subject to and possibly in a national park and could be expropriated, I would expect the price to be discounted. How big that discount is, is a bit in the eye of the beholder because it's taking exceptional risk.
I suggest to you, Mr. Kazmarek, that you didn't think for a moment that $1,200 was a price that anybody would pay for that lot. Do you disagree with that?
I absolutely disagree with that.
Well,
I've said in many other arbitrations about companies being subject to expropriation, not just land, but if you know there's a high degree of risk that a company or land might be expropriated, a nominal price wouldn't be surprising to see.
I'd ask you to look further in the document that that you have open in front of you to page 6 of that document. The numbers are in the very small print on the top right of the page. You see that?
I do.
And you see, Mr. Kazmarek, that in the same document that you reviewed, there's an indication that there were 2 mortgages on the property, one in the amount of $370,000 and one in the amount of $80,000. You see that?
I see the $370,000, yes.
And then if you look towards the top of the page,
I see it, yes. I see that reference.
so are you suggesting to me that when you looked at this document and saw that somebody had mortgage in excess of $400,000 US dollars on the property, that you actually believe that the purchase price was $1,200?
Well, this is in July 2018, right? Sort of 2008. I don't know when those were entered, but I agree it's a conflict. Why then list the value of the property at some fraction of what it's really worth when I understand these registrations are supposed to be for tax-paying purposes?
Did you understand when you reviewed the document that there was a mortgage registered on the property for in excess of $400,000?
I'm not sure at the time when we looked at and prepared our first report if that is a factor we looked into. We just identified the conflict that the document says 500,000 colones. And Mr. Hedden said, you're right, that's what the value is. That's what the purchase price was.
Do you know on what basis the administrative appraisals assess fair market value? And by that I mean what methodology they used.
I don't know for certain, but I would be very surprised if it didn't include the comparable sales approach, particularly for properties that encompass one lot for a single-family home.
But you don't know.
I have, as we discussed earlier, I have not analyzed how they came about, their appraisals, what properties they may have used, how they deemed them comparable, how they adjusted them. I have not examined that in detail.
You agree that the CAFTA Article 10.72 is the proper measure of compensation for lawful expropriation?
It's clearly a legal question. I'm aware of what it says. I don't disagree that fair market value is an inappropriate standard of value in this case. It's just a question about how one actually measures it. Do you include the risk that it's in the park and expropriation, or do you exclude it?
On page 15 of your initial report, you refer to the CAFTA, Article 10.7. In footnote 32, is that right?
Footnote 32?
Yes, footnote 32 of your report on page 15. You say, we understand DR CAFTA defines that fair market value should be the standard of value that is applied in the case of expropriation. You see that?
Yes.
And did you look at Article 10.7 sub 2 of the CAFTA in preparing your report?
I don't recall. I'm familiar with it, though.
Did you apply the definition set out in Article 10.7 sub 2 in assessing the value or compensation for the properties in this case?
In my view, my approach is far more consistent with that clause. I think it is the clause Mr. Cantor read about the knowledge of the expropriation should not be taken into account, which means if claimants had already known about it, we're in a situation where we need to go back and do evaluation before there was any knowledge about an expropriation of the park, but they purchased their properties after that fact. So if I were to apply that, strictly speaking, it would seem to me I'd have to move even further back in time than their purchase prices and come up with a valuation at that point in time before it became known that there was likely to be expropriations.
I think in a very roundabout way you've answered my question, which is that you did not apply the definition of compensation as set out in Article 10.7 sub 2 in preparing your report. Is that right?
I have erred to the side in claimant's favor in applying that I did not go back before expropriation became known, knowledge of this, and take a appraisal of their properties at that time, say in 1990, before any knowledge. That could be a possibility. As a valuation date, and appraise their properties there, then information about a park and a possible expropriation doesn't exist. I didn't do that. I said it would be fair to give them their purchase price back, which would clearly be higher than it was back in 1990.
Perhaps I can try again. In preparing your reports, was it your intention to follow Article 10.7 sub 2 of the CAFTA?
If that's what claimants are seeking compensation on, then I don't disagree with it, then I would follow it. Absolutely.
That wasn't my question. Was it your intention in preparing your report to follow Article 10.7 sub 2 of the CAFTA?
The way you phrased the question is as if I just am doing by myself for the first time, almost like a claimant-appointed expert. Do I get into that? I didn't consciously get into it. I was aware of it. I saw what was being claimed, and I prepared a calculation that I think most reflects and is consistent with that particular clause.
You agree with the concept of severance damages as described by Mr. Hedden in his initial report, is that right?
Yes, I agree with the concept that a partial taking can leave the remaining less valuable. In principle, I agree with that.
And if I could ask you to look at page 53 of your report. Paragraph 151 and 152, you refer to, in paragraph 152, amount of compensation being already received. Do you see that?
I do.
And I take it that you don't mean that the amount of compensation has actually been paid in that amount to date.
I know that amounts have been offered. I don't recall if there may have been withdrawals made by claimants. I understand they need to make the request for the payment. But here I'm listing out my understanding of monies that has been set aside to be paid to claimants, which has not been taken into account by FTI in its analysis.
So you'll agree with me that there's a distinction between being set aside and being received?
Yes, as I explained, my understanding is you can request it and it will be transferred to you, and they simply have chosen not to make the request in several instances.
And you're not aware of what amount within the number that you've included in your report has actually been paid out, is that correct?
I don't recall sitting here how much claimant has actually requested to be paid and what has been paid, no.
And if I could ask you to look at the presentation that you gave this morning. Do you have it in front of you? Sorry, it's not in the blue binder. And looking at what is page number 7 of your report. Sorry, of your presentation.
Right, the Case-Shiller Index graph?
This is the index that you included in your report. Is that right?
Yes.
And turning over to the page, you've done a graph of the what you call FTI index. This is something that you've prepared, is that right?
Yes.
And it ends as of December the 8th on your timeline, because that is after the date of valuation of the valuation date, is that right?
Correct. Mr. Hedden did not provide any indexation values after 2008.
And if you could look at page 11 of the presentation that you gave this morning. This is a summary that you have prepared based on your review and consideration of the evidence, is that right?
Yes, absolutely.
And and sorry, when I say the evidence, I mean the evidence in this proceeding.
Of course.
And if you could turn to the next page, which is your timeline on page 12. You reference a date of July 2003 here, being the date upon which Ms. Unglob's property is declared in the public interest. Do you see that?
I do.
You understand that that declaration was not published until November 2003?
I said that in my presentation, yes.
And you understand that that declaration was successfully challenged a number of times?
I absolutely understand that, yes.
You didn't include that in your timeline. Why is that?
Because the declaration to me, if you would like me to actually talk about why this was challenged, we're in the Unglaube issue now.
I'm not asking you why it was challenged.
Let me make the point, yes, the evidence in the Unglaube case is not before us, and we're not inviting you to go there.
I'm not asking you why it was challenged. I'm asking you why you didn't put in the date of the successful challenges.
Because to me, that's not really relevant. What was relevant was the authorities were declaring her property to be within the park. That is an indication to anybody in the marketplace that there's risk of buying properties within 75 meters of the 50-meter zone.
And if you turn to page 15 of your presentation.
$15?
15. You quote from the FTI report, and you quote, FTI is not an expert in terms of the claimant's motivation or perception of value. You see that?
I do.
I take it you'd agree that you're also not an expert in terms of assessing motivation.
I wouldn't characterize myself as such, but certainly in doing a valuation, one wants to understand if you're looking at whether it's fair market value, was there compulsion, was it a distress sale? And so you do need to look at the motivations of the party and try to understand the transaction better to see if it conforms to fair market value.
You refer in your first report to at paragraph 169 to the interest calculator that you used to reveal the legal interest, the legal rate of interest in Costa Rica. You see that?
Yes.
And that was the extent of the investigation that you did with respect to an applicable rate of interest, is that right?
I made the comment here that claimants were claiming this rate of interest. It's a legal rate of interest in Costa Rica, but also asking for it to be compounded quarterly. And so I made the point here that it's actually not applied that way if you put it into the website. It's applied on a simple interest basis, and that's consistent with my own experience about how legal rates of interest are applied.
Well, you have, in other proceedings, recommended or advocated in favor of compounded interest, correct?
Yes, but those are market rates of interest, which are usually substantially lower than legal rates of interest.
In your summary presentation this morning, you referred to Rosinvestco and Russia. You referred to a decision in your presentation, you recall that?
I did, yes.
And there's a related case, Yukos Universal Limited, Isle of Man, and the Russian Federation. You're familiar with that case, I assume?
I'm definitely familiar with that case.
Yeah, and you were an expert in that, expert witness in that arbitration, is that correct?
Yes, I was.
And in that arbitration, you recommended or you opined that the appropriate rate of interest was compound interest, is that right?
Can I just ask whether this is in the record? You objected previously to evidence in the Anglava case. So is this evidence that's in the record?
It is not. I objected on the basis that the Anglob proceedings were confidential, and there was evidence that was beyond what was contained in the award. I am referring only to what is contained
what's in the award. Okay.
My recollection was, which is typical of what we do in most cases, the Russian sovereign bond yield was an option, and LIBOR plus 4% probably, and prime plus 2. Those are the typical rates I recommend.
You recommended compound interest.
Right, on a interest rate that is a market-based rate and much lower than legal rates. For example, if my recollection is correct, in New York, the legal rate of interest is 9%, simple. And if I were to apply LIBOR plus 2, LIBOR is about 0.5%, I get 2.5% as the interest rate.
If I may just have a few moments. Thank you, Mr. Kaczmarek. Those are my questions.
Thank you. Ms. Hayworth-McCandless.
If I may just confer with my colleagues for a moment. We have no further questions.
Thank you. The tribunal does have some questions. Mr. Cantor.
Good afternoon, Mr. Kaczmarek. Thank you for attending. I don't think I need to introduce myself any longer. And I will not repeat my statement about why I'm asking a question about damages.
Of course.
But I did ask Mr. Hedden at the very beginning of my questions if he could describe his understanding of his responsibility to this tribunal. Could you please describe your responsibility to this tribunal?
Yes, my primary duty is to assist you. That's always my duty. It's frankly why I don't tend to use the word instruction. Clients instruct lawyers. I don't like to take instructions per se. I know it's a term used, but I'm sensitive to it because I want to be putting forward my own views to the tribunal and not necessarily the view of the party may adopt.
Before I ask more substantive questions, I have a technical question that I could have addressed to Mr. Hedden, but candidly forgot to do so. So I'm going to address it to you and see if you can help me with it. In looking through both expert reports here, I was struck that they appear to be on a pre-tax basis. As I review the land registry records and the summaries of them, it appears the properties are held in the name of corporations, and according to the memorials in this case, those may have been corporations serving as trust vehicles. It's not clear from the record whether there are any intermediaries between those trust vehicles and the claimants here. But the claimants in each case are U.S. nationals. The trust vehicles in each case are Costa Rican nationals. Could you help me understand treatment of Costa Rican taxation for purposes of valuing claims by the claimants here?
Absolutely, a topic with which I routinely deal with. My view is I don't think you need to worry about it. Taxes need to be paid in the ordinary course of business. If you were to make an award, assigning a value to those properties, and there is, let's say, perhaps capital gains tax to be paid, the capital gains tax should be paid by the claimants, not set off in any way in this case. If they have vehicles in between in which they have tax havens and are able to limit or avoid taxes, that's fine. But to me, taxes ought to always be done post-award, not within the award.
If the property that is the object of the alleged expropriation is owned by a vehicle, and the Costa Rican government pays an expropriation amount, do you know to whom they pay under Costa Rican law?
To whom they pay taxes?
No, to whom they would pay the expropriation sum?
Very good question. My presumption would be that the amount would have to go to claimants, or one of which is a corporation, Spence Co. but I am aware of other awards that have been settled and agreed in different ways, and so that's a possibility too.
And if it develops that claimant's expert has a different view and could communicate it to claimant's counsel, I'd be glad to have that information provided, because I really should have asked that first of claimant's counsel.
We will certainly do so. Thank you.
Thank you. On the Case-Shiller Index, my understanding is that real estate prices in the United States, the impact of the recession, which began in December 2007 and ended in June 2009, was disproportionately felt by 4 particular states: Arizona, California, Florida, and Nevada. Why, in those circumstances, would an overall United States real estate measure be useful in understanding particular property in Costa Rica?
Sure, and just to clarify, I think you're absolutely right. The recession began in '07. It wasn't really known, however, until much later in '08 that the economy had entered a recession.
For the record, I just finished reading Tim Geithner's memoirs, and he disagrees with that.
Okay. He's entitled to his opinion for sure, given his stature. But obviously, California, Florida, to the extent the recession had a much, and I assume you're talking about real estate, because, Miami got crushed in this. And of course, I think those are perfectly appropriate markets to look at. These are warm climates with beaches in which people would buy property, and they would have to choose an alternative. Do I want to buy in Florida? Do I want to buy in Costa Rica? Do I want to buy in California? So I absolutely think, because of that characteristic, it makes that index highly relevant.
Let me ask the question a different way, because I wasn't quite thinking about the weather in the Sand States. I was instead trying to understand why, given that purchasers of property, buyers in the Gold Coast of Costa Rica, might not necessarily come from the 4 states that disproportionately affected real estate prices in the United States. Why shouldn't indexation, if any, to U.S. properties look at the geographic locations of U.S. or Canadian buyers, not treating the entirety of the United States or the entirety of Canada as the proper measure?
Sure. The Case-Shiller Index, you can break it out. They do regional indices as well. And of course, we're looking at single-family homes. If we could hone in on our second homes, right? This is really the market, and I think both sides agree in Guanacaste. So if you could break it out that finely, I would absolutely agree with you. You have a better measure. It would be more correlated, I think, in that regard. But I think the same trends, when you see prices in one market and it's being driven by the same buyers in another market, the United States, and they follow the same trends, to me it's clear there's a correlation. If I had really good data, I could do a regression analysis and see how correlated they are. But I just don't have really good data to do that indice in Costa Rica.
Prices dropped more precipitously in the 4 states that I've mentioned than in the rest of the United States. And all 4 of those states are famous for being second home states. Does that suggest to you that the buyers from the United States, at least in Costa Rica, weren't, as a proportionate matter, less likely to come from those 4 states than they are from other states, because they would be seekers of second homes rather than holders of second homes?
I think where the buyer resides, to me, is not as important, because clearly any person in New York could be looking to buy a property in Florida as a second home. just like Costa Rica. So the buyers could kind of reside anywhere in North America. But what I do think is the fact that those markets being more likely to be second home markets and the impact they felt is more akin to what I have observed through my analysis that happened in Guanacaste.
You testified a bit about the Unglabe Award, and I want you to answer this question only by reference to the award, which is in the record. Is it possible to determine from the award amount, a price per square meter for the Unglabe properties?
I believe so, yes.
Do you have any recollection of what that would be?
I do not, sitting here.
Do you have a ballpark recollection?
My recollection was the frontage of the parcel along the 50-meter strip was 100 meters. And so 75 times 100, I think it was 7,500. That's my recollection.
So 7,500 meters divided into the principal amount of the award?
Correct.
And then taking account of interest. I think I can do that sum. Thank you. Does the face of the award include information about what your client in that proceeding advocated as the price per square meter?
Yes.
Do you have a recollection of that?
It should be in the award. You should be able to get, it should reference the total nominal price. I just caution that, and you can see this in the award, there were claims for things beyond the 75 meters, and so some prices are going to reflect that.
And do you recollect the valuation date?
It was mid-2006. That's clearly stated, and the award clearly states the parties had no disagreement about that being the peak of the market.
And which of the properties at issue in this proceeding would you regard as most comparable to the Unglabe property?
Obviously, the B lots, given they're adjacent to the property, would be most comparable. If I could just add, and it's clear from the absence of any dispute about it, again, we did not dispute what Mrs. Unglaube was entitled to, which was a value absent any risk of the property being in the park.
You made that point in your testimony. Thank you. You may recall that I inquired of Mr. Hedden about a methodology the tribunal might use to try to separate out the nature of regulation by government that would either be lawful or would not be expropriatory from regulatory measures that would be unlawful or expropriatory. Could I have your answer to that question as well?
Sure, and I deal with it all the time, but obviously I deal with it in ways in which claimants formulate this. A claimant will typically identify a number of measures a state has undertaken which they believe are unlawful or in breach of a treaty. My job is to calculate the quantum of the loss. It's really then for the tribunal to figure out, not for me to figure out. I can make my own personal judgment in a case, but it's not for me to offer that to the tribunal. But it's the tribunal is really then has the task of deciding which measures fall into the unlawful bucket and which measures are reasonable exercises of regulatory authority.
Again, a question of methodology. Mr. Hedden has offered principally a comparative properties methodology, and you take two positions on that. First, you assert that the comparative methodology was improperly applied, and second, you assert that by virtue of knowledge, the purchaser held at the time of initially entering into the purchase, that is not an appropriate methodology, but rather purchase price itself at that time is a proper methodology brought forward on the basis of the legal rate of interest. Are there methodologies other than those two methodologies that this tribunal could use for purposes of determining fair market value in these circumstances?
So just to clarify, any other methodologies other than comparable sales or purchase price adjusted with a return?
Well, adjusted with interest.
Right. Obviously, if it helps, and I may not answer your question directly, I'll get to it indirectly. Because I see the decisions before you, if you get to the quantum stage, I don't see that there's that big of a dispute between us and what you have to decide. For example, the threshold issue in my mind is you need to decide, are they entitled to a value with the risk of expropriation and it being in the park or without? Mr. Hedden has clearly offered a view that it shouldn't affect the valuation, and we say it should. Right? If you say it should affect the value, the risk of it being in the park, I think what I have prepared, other than the fact that I really can't be confident in the purchase price data, is the appropriate approach in this case. If you decide his view is appropriate, then I think you're into a different set of what I've tried to describe are my disagreements. The market's being, he misanalyzed the market, his implementation of the comparable approach, I think, is got some flaws, etc. So there's really two tracks to take, I think, to resolve the issues, and I don't think there are that many decisions before you to figure it out.
Thank you for that advice. Let me try this a different way. I think we all would accept that there are some properties here that would be outside the 75-meter band, but nevertheless subject to the same non-expropriation regulatory and physical risks. For example, water, permitting, unrelated to the park, and the like. Would that be correct?
I think there are some issues there, but I don't understand claimants to be making any kind of claim about that.
Bear with me,
Sure.
I'm taking it step by step. Do you agree that there would be properties like that? Not at claim in this dispute, but properties like that?
Absolutely. There'd be properties outside the 75-meter strip that might have density, building height, restrictions and such. Yeah.
For purposes of trying to determine a value of that kind of a property in a market that is illiquid, very few transactions, and subject to high price uncertainty because of economic circumstances. If you were to take the purchase price for the date the property was initially purchased, at some point after, in your opinion, that purchaser would be aware of the existence of the park, so it would be comparable but not subject to expropriation risk, that property would nevertheless remain subject to the more ordinary development risks of any property, but it would still be in general in the same geographic location, so it would be subject to risks such as water and the like. Okay. It'll be a roughly comparable in that sense. Property might not benefit from the views, something like that.
Agreed.
Okay. If you took that purchase price, would it be appropriate in thinking about the value of that property in the hands of the holder to think about the appreciation in value of that property on the basis of an annual rate of return up to the date one sought to value it?
Yes, you could do that, either like an interest rate or a market index of some sort, if you felt you had one. But yeah, that's an appropriate approach, yes.
Typically, an interest rate would be lower than the owner's interest, wouldn't it be? Because the owner's interest is an equity interest.
Well, in this, if you're holding equity, sure. Here you're holding an asset. The most appropriate index would be a real estate index of, had you sold this, sold it and put it somewhere else, right? Took the money, put it somewhere else that has the same kind of risk characteristics as the investment that was actually made.
And that would typically be higher than say, a statutory rate of interest in Costa Rica.
Depends upon the circumstances.
I understand that,
Yeah.
but more often one might expect real estate, if it was going to appreciate, the value of real estate over the long run, subject to variations from year to year, would appreciate at a rate higher than a statutory rate of interest. Would you agree with that?
I agree entirely with you. Over the very long run, real estate does go up 100%. It really depends upon the timeline. I'd have to run the numbers because some of the legal rates of interest that I see are quite high. It's just comparing one that's not compounding with one that is compounding. But likely, I think, it's likely to be higher.
In light of what you've just said, then, would an appropriate alternative way of thinking about how to calculate value for these properties be to find the initial purchase price for these properties, taking account of characteristics, if any, that are outside the ordinary in the purchase contract, and then appreciate it over whatever time period the tribunal considered to be appropriate up to a valuation date at an average rate of return for properties similarly situated but not subject to the expropriation risk.
Yes.
Severance. In looking at discussions of severance, most of the testimony by Mr. Heaton on examination and cross-examination and your own testimony seems to have focused principally on the properties that are shown in figures 9 and 10 of your report. If I recollect the testimony about the B lots correctly, though, in some cases, a portion of a lot that claimants characterize as beachfront property was taken, the beach side of that property. Why wouldn't there be a reduction in value for the remaining portion of that property because it is no longer as close to the beach, and at least on claimant's evidence, it is said that it cannot be developed as easily because of zoning restrictions?
Right. In that case, you can think of it, and it's really a continuum, but they're fairly sizable lots. And you could say that the first 10 meters is the most valuable, and then it decreases thereafter. So from that perspective, again, the part that is remaining, you could say has the same exact value as it had before, because you have an average value for the whole lot. Some that's higher, close to the beach, some that's lower, away from it. And in that sense, again, there's no severance damages in my view. Also, as was discussed today, I guess and throughout, Mr. Berkowitz does own properties behind and can, submit a different plan and organization for those lots. And so in my view, I still think they retain the same value that they had before the taking.
Would it be correct, though, that the remaining portion of those, the unexpropriated portion of those lots that were characterized as beachfront, if the claimant's evidence that the zoning regulations make it harder to develop, are both farther away from the beach than the lot originally was, and it's a single lot, and more difficult to develop, and that would either directly affect the remaining portion of the lot or would have an impact by forcing combination with other lots that could have a follow-on impact to the value of those other lots. Do I correctly understand that?
I think I understand what you're saying, yes. If claimants are right, that this creates zoning problems for the remaining portion, and there is no other portion to be joined to these remaining portions. If that evidence is correct, per se, then it's possible that those remaining portions could suffer some diminution in value. I mean, the easiest example in my mind that comes to my mind about severance is you can imagine someone has a home and they want to widen the street and they encroach on their property, and so they take a portion of their property. But the remaining portion now, maybe the house is situated very close to the road, which does not make that remaining portion as desirable as it used to be. That's severance damages. I'm just not sure from what I've seen that it exists. But yes, if there's problems to develop those remaining portions, in principle, there could be some loss in value.
One last question, just clarification. Could you turn to page 24 of your slides? There were times in your testimony that I thought I understood what the FTI index was, and there were times where I thought I didn't understand what the FTI index was. Could you please explain for me in simple words?
As it applies to this chart here, yeah.
Correct.
Okay, so what we did here to create this chart is the blue bar is the purchase price, and we just normalized everything to put it at 1. Here's the starting point. And then we said, okay, we apply their index, the one I graphed on slide 8, we apply that index to the blue bars, you get to the red bar. And then we compared the red bar with the green bar, which represents the change in value according to what Mr. Hedden's valuations are of the properties in his report, and made the observation that other than for Kofer's lots, everything, all the green bars are substantially higher than simply applying the index to the actual purchase prices.
And going back to slide 8, can you describe what you understand that, quote, index, unquote, to be?
Right, so what Mr. Hedden did is he did what he calls a paired sales analysis. And he took the same property, purchase price at one date, and observed a purchase price at a different date. And from that said, okay, I think the market was going up 2% a month, and this year 3% a month, and this year slows to 1% and then 0. And from that's how I understand his analysis. And then that was the basis for him to make adjustments for any properties he deemed comparable at different dates and time.
Let me put this in my own words to see if I correctly understand what you're calling the index here. It's the incremental increase in value for the claimant properties over the relevant time period.
The incremental increase in market prices, not necessarily for claimant properties, but market prices. That's his view.
Okay. Thank you for that explanation, and thank you for your patience. No additional questions, Mr. Chairman.
Mr. Kaczmarek, just one question from me, and it's the most basic practical point of clarification. In page 19 of the slides that you provided to us at the start of your testimony, you source this as coming from your second report, tables 8 to 10. And I just want to be clear what the slide is, because tables 8 to 10 of your second report are both slightly different in format and try and address rather different things. Is there any correction that this slide is making, or have you just reorganized the material in slides in tables 8 to 10 to present them in a slightly different format?
It's just a slight reorganization of the data, yes.
So we're not going to find any inconsistency or between the tables 8 to 10 in your second report and this table. We can consult them both.
There shouldn't be. I will double check that, though,
Okay.
since you raise it as a possibility.
Thank you very much. Thank you very much, Mr. Kaczmarek. Thank you for assisting the tribunal, and you're excused from the witness seat. Thank you.
Thank you.
Counsel, I'd like just to take the briefest of recesses, just for 2 minutes. I don't invite you to leave your seats. I would just like to confer with my colleagues about proceedings from now. Thank you. Thank you very much. We're now approaching 5:30. We've been going since 2:30. We had speculated that it may be possible to use whatever fallow time there was at the end of today to answer questions. I don't propose that we do that now, because I think in any event it would be appropriate to take a little bit of a breather were we to continue, and that would mean that we'd be coming back with 15 minutes. I'm proposing that we adjourn shortly for the day. As regards tomorrow, I propose again that we keep to the timetable that I put to you yesterday, and that is that we will have a 9:30 start and then run through till 12:30 for the claimants' closing submissions. We'll then break from 12:30 to 2 o'clock. We'll then reconvene from 2 till 5 for the respondents' closing submissions. We'll then have a break for the tribunal to confer and come back for closing formalities. So that will allow a block of time of approximately 3 hours with a brief coffee break in between for both parties to respond to questions from the tribunal and to make their closing submissions. I understand from the tribunal secretary that both parties have more or less used up a similar amount of time, but that we do have a comfortable period of time, so there is no issue of inequality between the parties. Unless I hear an objection from either party, what I'm proposing is that we simply afford you each that 3-hour block of time tomorrow to use as you see fit to respond to questions and to make your closing submissions, rather than invite you to pop up and down and say when you're responding to questions for purposes of timekeeping. I don't think that we're in that zone. So if you're content with that, you've each got 3 hours left, less a coffee break for your closing submissions tomorrow. The reason for just wanting to suspend briefly was just to check with my colleagues whether there were any general questions that we would like to put to you in addition to the ones that we've raised already, to give you notice of them tomorrow. I think the only general question, and it's not a question with anything specifically in mind, and it's put to both parties, is that it comes from me, and that is that we heard from counsel for El Salvador in his non-disputing statement that we ought to have regard to Chapter 17 of the CAFTA, the environmental chapter. That hasn't been part of the parties' pleadings. So it's really simply an invitation to both parties to take any opportunity that you may have tomorrow to draw our attention to whether you consider that Chapter 17 is important. This is not a proposal to change the nature of the case at the last moment, but as the matter was put on the agenda in the oral submission from El Salvador, I wanted to ensure that you had an opportunity to comment if you wanted to do so. And I think with that, unless there are any sort of submissions, procedural points, or other practicalities that either party would like to raise, I'm going to draw the proceedings for today to an end, and we'll reconvene tomorrow at 9:30. But let me just give each party an opportunity to raise any issue. Mr. Kauper, anything from you?
None on behalf of the claimant.
Mr. Alexandrov?
We are in agreement, Mr. President.
Okay, well, thank you very much, and we will see you tomorrow at 9:30. And I know the stresses and strains that come with the preparation of closing submissions overnight, so I won't wish you a happy evening, but we look forward to seeing you both and to be illuminated further tomorrow. Thank you.